get out.
Episode 18, Dobbs overturns Roe, a new landmark abortion case. In this episode, we discuss the new landmark case that came down from the Supreme Court earlier this summer. The Dobbs decision overturns Roe v. Wade and Casey v. Planned Parenthood, two cases that are probably revered by one-third of America and hated by another one-third of the country. We'll look at the situation before this decision and also consider what will happen after this decision. Welcome back to the For Legal English podcast. Our summer extended vacation is now over. We are locked and loaded for September. We'll have weekly episodes released every Thursday, which in September we have 5 Thursdays, so we're going to have 5 episodes in September. So please subscribe, give us 5 stars, and share this podcast with your friends and colleagues. It would really help us grow. Welcome to the For Legal English podcast. This is the show for lawyers, law students, and other professionals from all over the world who want to improve both their legal English and legal knowledge. In this podcast, we discuss different legal topics, such as law in the news, law in practice, legal writing, legal movies, and other issues. I'm Timothy Barrett, your host. I'm a former practicing attorney from the U.S. and now a law professor in Tbilisi, Georgia. Go to our website, 4, as in the number 4, Legal English, no spaces or dashes.com, 4legalenglish.com. Check out our blog articles, available courses, and the show notes for this episode. On the docket today, episode 18, Dobbs overturns Roe, a new landmark abortion case. Dobbs. So the case we're going to talk about today is Thomas E. Dobbs, State Health Officer of the Mississippi Department of Health, et al., who are the petitioners, versus Jackson Women's Health Organization, et al. And et al. Is, of course, Latin for and others. Often there's more than one party to a Supreme Court of the United States case. Sometimes there are 2 or 3 cases with the same legal issue, which are even merged to form one case, which then the court decides. The opinion in this case was issued on 24 June 2022. This is clearly a landmark case, quite possibly the most important case in my lifetime, both legally and politically. Will the effects of this decision be that important? I'm not really sure. It's kind of interesting to see, but certainly the decision itself is a landmark decision and has been argued about before it was even issued, and it's going to be argued about long after the court moves on to other cases. This was a huge case in the political world, as well as legal world. And this is probably also a win for originalism or the textualists, those members of the court, as well as legal scholars, who believe that the Constitution is composed of words that you have to understand and follow. You can't just make up rights. You have to read what is written and apply those words to the case in front of the court. It's up to the people to amend the Constitution if they want to add more rights, but it's not up to the court to add more rights or invent more rights when there aren't any rights written there. Prelude and backstory. It's important to keep in mind that in the United States, abortion is a very politically sensitive and contentious issue. Often when you're talking to people, if there's 1 or 2 or 3 areas not to talk about, abortion is definitely one of those areas. You don't want to talk about it if you don't want to get into an argument with the other person, especially if you don't know what they believe or which side they are on. It is very much a hot button topic and very polarizing. Many people in the country feel very strongly one way, and many people feel very strongly the other way. And of course, there may be some that are kind of in the middle that don't feel strongly one way or the other, but that's not most of the people. The two main sides are often called pro-life or pro-choice. The pro-life argument is that life begins at conception. So as soon as that egg is fertilized, that's a unique human life, and therefore is entitled to protection, is entitled to due process, as well as the right to life, which is part of the Constitution. The pro-choice argument is that the mother's right to choose trumps anything else. So the fact that this fetus is inside the mother's body, the mother gets to choose what to decide to do, whether they want to keep the baby or get rid of it. And that no one should be forced to carry a baby to term for 9 months if that's not what they want. If that's against their will, then they can't be forced to do that. We've talked briefly before in this podcast about confirmation hearings, how federal judges, especially Supreme Court judges, are chosen, how they're nominated by the president, and then go through hearings in the Senate, where the Senate will vote up and down. Do they want this person to be approved or to be rejected? These confirmation hearings in front of the Senate Judiciary Committee are very contentious. Normally the most contentious hearings in Congress. And it's been going on that way, really since the mid-'80s. This is one of the questions that the senators will ask the nominated judges. And it could happen behind closed doors or in the committee hearing, where they will ask about this, is Roe settled law? Will you vote to overturn it? That sort of thing, those types of questions. And as time goes on, the judges are or prospective judges are much less likely to answer those kind of questions or answer any questions, really. It kind of became clear after Judge Bork and certainly after Clarence Thomas that your best bet to get approved is probably not to say too much, just to kind of keep your mouth shut, say as little as possible, and hope that those that are going to vote for you are going to vote for you anyway. Those that would vote against you maybe are going to vote against you no matter what you say anyway. So just kind of get through it without making any mistakes, which I think most of the nominees kind of take that approach, whether they're from a Republican president or a Democrat president. The last several have kind of taken that approach. Abortion is a huge political issue. There have been so many political fundraising campaigns based on Roe and the decisions that follow it on both sides. So sometimes people even wonder, do the politicians want to even change the status quo? Because no matter what side the politician is on, they can use this case, the prior precedent, Roe or Casey, to raise a lot of campaign money. And certainly after the Dobbs decision came down, a lot of campaign money was sought as well. A leaked opinion. So this has never really happened before in the Supreme Court. A draft opinion for the majority was leaked. Someone on the inside of the court's chambers leaked this opinion to the press. The leak itself was on the 2nd of May, and the opinion wasn't issued till almost 2 months later at the end of June. This is definitely a black eye for the court and for the Chief Justice Roberts, who I think is responsible since he is the Chief Justice, but also by his temperament takes what happens with the court in this type of issue very seriously and I would say also very personally. It's often been stated that he has changed his decision on certain votes just to kind of preserve the integrity of the court, or what he saw as the integrity of the court. As we're recording this podcast, we're approaching 4 months after the leak, and it appears that there's no progress. It appears that we're no way closer to identifying who the leaker was as we were on the 3rd of May, the day after it happened. This is very frustrating for several reasons. One, this has never happened before. And in a time in the United States where many Americans are losing faith in the institutions, this is one more reason to lose faith in institutions. And another reason is there's not that many possible candidates that could have leaked it. I've seen different reports, sometimes as low as 50, others maybe around 75 people who would have had access to the draft opinion. So that's kind of a very small universe for them to identify, interrogate, and find out who actually leaked the opinion. Besides the 9 justices themselves, the leading contenders are the clerks. Each judge will have a few clerks that will help them do their research and draft their opinions. And these are very prestigious positions. After graduating from law school, a new lawyer would apply to the court of first instance, the trial courts in the federal system, as a clerk. And some of those will be selected to kind of extend their clerkship under the court of second instance, the appellate court judges. And then from that list, some of those will be selected as a Supreme Court clerk. So this is very prestigious, and it really sets up their career for the rest of their life. Often it's been described that as soon as they finish their clerkship, they'll get a position and make more money in their first year than the Supreme Court justices will make themselves. And in fact, a handful of the Supreme Court justices now were clerks of other Supreme Court justices in the past when they started their legal career. So it is a very, very important, very prestigious position. It is most likely one of these people who has leaked the opinion. And you kind of have to wonder as an outsider, if they haven't figured it out now or released who it is, then maybe they're never going to find out, or they'll never release the information. Who knows? But certainly they had long enough time to kind of go through the list of names and make some progress. And this leak has certainly had some influence outside of the courtroom. There's been a very strong backlash against some of the justices as a personal level, even protests outside of their homes. The judges that voted for the majority, I believe, have all had to kind of vacate their homes outside of Washington, D.C. and have to live in undisclosed locations and for the foreseeable future. And in fact, one person was arrested near Justice Kavanaugh's home who reportedly was going there to try to kill or assassinate Justice Kavanaugh. And although protests outside the Supreme Court are not new, and throughout Washington, D.C., in the Washington Mall, by the Washington Monument, places like that, there's often protests. But this is very unusual to have it at the justices' houses, at their homes. Usually that information is kind of safeguarded, and even those in the press that know about it don't share that information. But those kind of rules of decorum have been thrown out the window. And it's not just the justices that are facing this. Many pro-life centers that provide alternatives to abortion have been attacked. Some might be kind of low-level graffiti, things like that. Others have been much more violent against people and to the property. Federal law enforcement seems kind of slow to react to a lot of these threats and seems to be focusing on other areas instead of these issues. If you're enjoying today's episode, please subscribe, give us 5 stars and a review. Go to the website 4 as in the number 4, Legal English, no spaces or dashes.com, 4legalenglish.com. Check out our blog articles, available courses, and the show notes for this episode. And please comment. It's a great way to practice and improve your legal English skills. If you're looking to improve your legal English skills, consider the conversational course. This course involves one-on-one tutoring, tailor-made towards your goals, and considering your level. This is a great way to kick up your legal English skills. For more information about this exciting course, check out the website. Prior precedent. Roe v. Wade was decided in 1973. At that time, abortion was becoming a political issue. Probably wasn't quite the issue that it is today, but it was becoming one. And some states were drafting laws allowing abortion or setting up the rules when abortion would be allowed. Traditionally, abortion was outlawed. It was not allowed under the common law system. But the Roe decision took this issue away from the states and made it a federal question. Instead of going through the normal political process where each state can kind of decide, and over time, maybe there'll be a consensus throughout the country, but it'll develop kind of naturally through the people in their political process. this became a federal question and more of a judicial question. It was something for the courts to decide, not the legislatures. And the decision itself was kind of weak, argument-wise, logical-wise. Even many pro-choice advocates, such as the late Ruth Bader Ginsburg, other legal scholars, they thought that the opinion was poor, not solidly based in the Constitution or constitutional reasoning, even though they agreed with the outcome. So there are many legal scholars with that position. And when Roe was decided, it was more permissive of abortions than any state was. And it was also more permissive than most countries were at that time. And since the very beginning, this was a contentious case. Approximately 20 years later, the court revisited Roe. In that case, Planned Parenthood versus Casey, they ended up modifying Roe and the understanding of Roe, but they kept it alive. They did not overturn the Roe decision. In both Casey and Roe are very complicated cases. Even for Supreme Court cases, they are difficult to follow. But some highlights from those cases: they found a constitutional right to abortion, and they weighed that right with the state's interest in protecting or preserving the unborn life. The state's interest would increase over the development of the fetus. As the fetus was closer to being born, the state had a higher interest. When the fetus was younger, the state had a lower interest or lesser interest. An important factor was viability, which is the capability of continuing to live outside of the womb or outside of the mother's body. And this initial understanding of Roe did not really age well. Remember, Roe was about 50 years ago. This was before sonograms or ultrasounds where you can see the baby and even see the baby moving. Another problem with viability is it has the problem that it changes over time as well as at medical facilities. For example, a fetus in 1973 that was X weeks along or this type of medical condition might not have been viable, but in the 1990s or in 2022, that same fetus might be completely viable. As well as if you're inside a top hospital in New York, or maybe stuck on the side of a mountain somewhere far from advanced hospitals, then the viability would be considered different. Organization of the opinion. Remember, there are 9 justices on the court, 1 Chief Justice and 8 Associate Justices. Each has a single vote. Justice Alito delivered the opinion of the court, in which Thomas, Gorsuch, Kavanaugh, and Barrett joined. So that is 5-vote majority. Justices Thomas and Kavanaugh each filed concurring opinions, where they agreed with the judgment, but maybe had a different analysis or additional analysis that they wanted to include. The Chief Justice, Roberts, filed an opinion concurring in the judgment. So not with the majority opinion, but in the judgment, that is, who would win the case. And this is pretty rare, that a justice would concur in the judgment, but not in the opinion. And Justices Breyer, Sotomayor, and Kagan filed dissenting opinions, dissenting from the majority opinion. It's interesting when you compare the leak with the final opinion, they both seem very similar. I went through a part of it, and a lot of the changes that I noticed were things like citations or formatting, maybe additional information, something like that. But I didn't see anything that really changed the content of the draft opinion. But I didn't bother to go through the whole thing like that. But there are some websites that do that. They compare them side by side and point out the changes. From the majority opinion by Justice Alito, quote, Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences, close quote. This decision, this opinion, clearly overturns prior precedent. It overturns Roe as well as Casey. And this is pretty rare. The Supreme Court, for all its talk, doesn't really overturn a lot of cases. They like to distinguish prior cases. They might point out that old case is still good, but in this situation, we're going to do something completely different, but not outright overturn that prior precedent. But here they do. If you are interested in reading it, it is much easier to read than Roe was, so it isn't a bad place to start at all. Justice Alito kind of goes through a lot of the history, and the dissenting opinion refutes some of that history as well. Of course, they have very different arguments, but it's interesting to go through all those arguments. And if you do, I'd be interested in hearing what your impression on it is. Who has the better argument, the majority or the dissent? Outcome of this decision. So the bottom line, the court ruled that this is not a federal question, but a state issue and should be decided by states. So they didn't outlaw abortion by any stretch. In fact, overnight, very, very few things, if anything, has changed. Remember, the U.S. has 50 states, and now each can set its own law in this area. And this was the situation before Roe was decided. So it kind of turns back the clock 50 years. And what does that mean now? Well, some of the states don't have laws one way or the other about abortion, so the status quo is maintained until they pass new laws. So in those states, it's going to be the same as if Dobbs wasn't decided until the state legislature, makes some changes. Now, other states have laws already protecting abortion. And so those protections, those legal protections will be there just based on state law rather than federal law or the Supreme Court decisions. In other states, I think 13 states have laws that would automatically kick in if SCOTUS, the Supreme Court of the United States, ever overturned Roe versus Wade, which Dobbs does. So some of those will be effective immediately or became effective immediately when Dobbs was issued, or after a certain time period, or in some states, the state attorney general has to make a finding, and then those kind of dormant state statutes will become effective after that. And 2 states have already attempted to change their law in response to Dobbs. In Kansas, they attempted to be more restrictive, in other words, more pro-life, but it was rejected. There was a referendum, the voters rejected it. In Indiana, they did vote to become more restrictive, so more pro-life laws. Comparison. How does the U.S. compare with the rest of the world? I've read a lot of articles in the United States as well as outside the United States kind of claiming that the U.S. is now taking on a very drastic or extreme position on abortion compared to the rest of the world. But I don't think that that's necessarily true. The U.S. is one of only 7 countries in the world that permit elective abortions, the mother's choice, past 20 weeks. So it's pretty rare for countries to allow that. The U.S. already has one of the most permissive abortion schemes in the world. Most states in the U.S. and countries in the world are focused usually on the first trimester, the first 3 months. For some reference, I believe both France and Spain have a 14-week limit, but other countries have longer, Sweden up to 18 weeks, and the Netherlands up to 24 weeks. But I think overall, the United States is certainly not more restrictive than most countries in the world. Some people in the United States that might live in a state where abortion is restricted or more restricted now than it was before may end up going to other states to get their abortion. And there's been a lot of talk, some states kind of encouraging that, or some employers offering to pay for that or subsidize that sort of thing. So I don't think it's going to be very problematic for that to happen. And it's not realistic that anyone is going to prevent that or anything like that. I don't think there's much of a risk of that whatsoever. Since the Roe decision came down about 50 years ago, approximately 63 million American babies or fetuses have been aborted. And if you think about it, there's about 335 million Americans today. That's the population. So realistically, if abortions were completely outlawed, the population of the United States would be over 400 million. That's quite a difference. Worldwide, it's estimated that there's over 32 million abortions every year. Terms. Were there any legal terms or today's topic, perhaps medical terms or political terms that you were unfamiliar with? Some of the terms I pointed out were landmark case, originalist or textualist, pro-life, pro-choice, viability, overturn, concur, dissent. If there are any other words that you had trouble with, then post them in the comment section on the show notes, and I'll try to explain what those words mean. Remember to go to our website, 4 is in the number 4, Legal English, no spaces or dashes.com, 4legalenglish.com. Check out our blog articles, available courses, in the show notes for this episode. You can comment on the show notes. This is a great way to improve your legal English skills. If you have any questions about today's topic, go ahead and ask them there. If you could subscribe, give us 5 stars in a review, then that would be great. Next time on the docket, we're going to look at using templates and writing precedents in legal writing. If you're looking to improve your legal writing, stay tuned for the next episode. The 4 Legal English podcast is adjourned. Don't miss the next docket call.